Welcome back to Commercial Law 2. We will be looking at the law of contract. There are many dimensions of contract law. First, there are three separate theories in the law of contract to consider. The first is the promissory and the will theory, which focuses on the freedom to contract, which basically means that parties are free to enter into contracts with whomever and on whatever basis. The promissory theory is based on the unilateral will of a party. Think of a gentleman's agreement. Whereas the will theory is bilateral. In terms of the will theory, the law should enforce obligations that are assumed through the meeting of the minds. However, the courts have criticized these theories in that one can easily enter into a contract that is contrary to public policy. Furthermore, these theories overstate the strength of protection that parties have in order to enforce a contract. We swiftly move on to the reliance theory. This theory states that the purpose of a contract is to protect parties from harm. The obligations in the contract can be enforced by law, and the contractual obligation must ensure that the person relying on the promise is not placed in a worse position if a contractual obligation is not fulfilled. This theory has been criticized on the basis that liability actually arises from the undertaking and not from the person's reliance, ironically. Finally, the relational theory is concerned with the effect that a contract has on the relationship of trust between parties. This theory views a contract as part of a relationship rather than a separate or single transaction. It also embeds social norms. Now that we understand the various theories applicable to the law of contract, we need to be able to identify and define a contract. A contract is, in simple terms, a written or spoken agreement that is intended to be enforced by law. They are usually legally binding relationships between parties, resulting in rights and duties between the parties. It is often difficult to determine when parties have reached consensus, a meeting of the minds, and the law thus applies an objective approach in this regard. The law of contract forms part of the law of obligations, which in turn is part of private law, or that part of the law which governs relations between private parties. The term obligation means that one party has a duty of some kind and another party has a corresponding right to claim performance of that duty. Performance entails doing something or giving something, or in some cases, not doing something, to the creditor or to refrain from doing something. A contract and an obligation are not the same thing. An obligation arises from a contract. There are also essential elements of a contract. These are referred to as the essentialia, and they are key terms that must be agreed upon for the particular type of agreement to be regarded as effective and binding. There are also naturalia and incidentalia. Naturalia are terms that automatically form part of a contract, arising through the operation of law. The parties therefore do not need to specifically include these terms, as they are automatically included. On the other hand, incidentalia are terms included in a contract by the parties for their own convenience. It is not necessary for parties to include incidentalia into their contract, but they may do so if they want to regulate their agreement to suit their needs. Let's look at an example. If Sally and Betty decide that Betty will buy Sally's commercial law textbook, the book will belong to Betty once she receives it. The essentialia of a contract of sale is the intention of the parties to purchase and sell, certainty regarding the object sold, and lastly, certainty regarding the purchase price. The naturalia of a contract of sale is that the buyer must pay and the seller must deliver the rights and duties determined by the naturalia of a contract, and that the seller gives an implied warranty against latent defects, an assurance that need not be expressly mentioned in the contract that the goods are free of defects, which the buyer would not be able to notice upon reasonable inspection of the goods. With reference to the previous example, incidentalia would, for instance, entail that the implied warranty against the latent defects, as mentioned under naturalia, may be expressly excluded from a contract. The very essential elements of a contract, which you should know like the back of your hand, for it to be valid and enforceable, are that the parties must reach consensus and communicate their consensus to one another, that is, by offer and acceptance. The parties must seriously intend the agreement to result in terms that can be enforced. There must be reality of consent between the parties. The contracting parties must have the capacity to contract. It must be possible to perform the contract. The terms of the agreement must not be vague. The agreement must be lawful. The parties must comply with the formalities where these are agreed to or imposed by law. If any of these elements are absent, the contract may be void or voidable. Now, I know these terms sound similar, but they do have different meanings. A void contract results in when there is a fatal defect so severe that the contract never comes into existence. On the other hand, if the flaw allows the aggrieved party to elect whether they want to contract and they want that contract to be valid or not, the contract is voidable. Furthermore, a contract will be void if it is unlawful. It'll only be voidable if it is concluded without free or voluntary agreements, such as through misrepresentation, duress, or undue influence. The legal consequences of a void contract is that it never came into existence, whereas a voidable contract is valid and enforceable until set aside by the aggrieved party. Since no contract exists in the case of a void contract, neither party can enforce it, whereas with a voidable contract, contractual and electoral remedies may apply. I will expand on contractual remedies a bit later on. Let us look at each essential element of a valid contract independently.